Welcome to Fasken's 2022 mining series. Hard to believe, but this is our 12th consecutive series. I am Virginia Schweitzer, and I'm a member of the Fasken Global Mining Group. Today's session is our third of 15 sessions, which continue till next Wednesday. Please refer to the slide on your screen for some housekeeping details following the presentation. Now I'll turn it over to my colleague, Tracey Cohen, the moderator for the Effective and Enforceable Dispute Resolution session. And Tracey will introduce today's panel. Thank you very much.
Thank you, Virginia. Nice to be with you all, at least virtually. Hopefully next year we will be in person. I'm Tracey Cohen, and I am a litigator in our Vancouver office of Fasken. I practice in commercial litigation and arbitration. And we have a fantastic lineup for you today. We are going to be, as Virginia mentioned, discussing arbitration, both domestic and international, and hopefully giving you some overview, at least, of how to make sure that your arbitrations are effective and enforceable, both from the start at the outset when you're thinking about your transaction documents and throughout the arbitration process itself. I have with me here today 4 panelists, 3 Fasken partners, and Geoff, Moysa, who I will introduce in a moment. But firstly, we have Leblanc, who is a partner in our Montreal office, who practices in commercial litigation and arbitration with a specialty in patents and intellectual property. And we have from our Toronto office, Rahat Godil, who just joined our firm recently from another national law firm, and we're super excited to have her joining us. She has a great deal of experience both in domestic and international arbitration. And finally, from Fasken, we have Wyke from our Calgary office, who has significant experience doing both litigation and arbitration with a specialization in construction amongst other areas. We also have joining us here today Geoff Moysa from Omni Bridgeway. Geoff is an investment manager and legal counsel in the Toronto office of Omni Bridgeway, and he will explain to you as we go through the topic this morning a little bit more about what that means. But he does have a background in litigation, was a partner in a national law firm, and practiced in litigation and arbitration for 10 years before joining Omni. So I'm going to jump right in today, and we're going to start by talking about the initial step of what do you do when you're drafting your transaction or agreements and thinking about arbitration. And I'm going to ask Karen to tell us a little bit about what the most important things to think about are in that context, and to address the what, where, and who of the drafting of arbitration agreements.
Yes, thanks, Tracey. I'm happy to kick off that discussion. And yes, in discussing enforceable and effective arbitration, the starting point is always an enforceable and effective arbitration provision. Of course, at any time, parties can submit their dispute to arbitration. Sometimes that can be done once a dispute arises. That's called a submission agreement. But what we're talking about today is submitting or referring a dispute that you have no idea what that dispute will be to arbitration at the time that you are drafting your commercial agreement. So we're going to look at, what are the bare minimum requirements to make that provision in your commercial agreement enforceable. And then we'll also look at what are some of the most effective provisions to include. So we've all known and discussed over the last decade or so the benefits of arbitration over litigation, and I think by now they're well known. We used to always kick off these webinars with canvassing all of those benefits, but there's the privacy and confidentiality, of course, of arbitration over litigation. There's enhanced finality of the award through limited rights of appeal. And then in the international context, of course, there's the enforcement of the award through various conventions. But the pandemic and particularly the pivot to virtual hearings, which I did also during that time, has demonstrated once again that one of the key benefits of arbitration over litigation is its flexibility, and that really, there's really no limit to how parties can configure their bespoke litigation through their arbitration provision. There's the what disputes are to be arbitrated. The contracting parties can really think about bifurcating. There's the where of the arbitration, and there's some ramifications about picking the place of arbitration we'll go through. There's who will adjudicate the dispute and who will be subject to the dispute. And of course, there's the how will the arbitration proceeding proceed. So there are procedural steps that need to be completed before the parties access the arbitration. Will the arbitration be administered, or will it be ad hoc? Will it be subject to different rules of evidence? So there's all these considerations. And first, we'll look at what's the bare minimum. What do you need to make it enforceable? And just to keep in mind, the arbitration provision, it's often referred to in a lot of texts as the midnight clause, that it's what the commercial lawyers draft as the last clause in the agreement or the last schedule. To us litigators and arbitration counsel, it's the sunrise clause. Anytime a dispute arises, it's the first provision I go to. I need to know, are we running against a limitation period to commence the arbitration? Are there arguments about the validity of the arbitration? Can we wiggle out of the arbitration? Are the timelines appropriate for the dispute? So, and you have to be aware that if there are drafting contradictions, or perhaps the arbitration provision isn't considered mandatory, that it can be held to be invalid, that the parties can be diverted very quickly to the courts to determine those things. So let's talk about what's the bare minimum. And let me just say at the outset that the bare minimum is slightly different in domestic arbitrations and international. So, and what is an international arbitration versus a domestic? Well, a domestic arbitration is generally where two parties from the same, or two or more parties from the same state are in a dispute, and they pick the place of the arbitration as that same state. In Canada, you will be subject, and this is across the provinces, to domestic arbitration legislation with slightly different rules. Now, if you're in international arbitration, again, disputing parties perhaps from two different states, or even if you're from the same state, but you choose the place of the arbitration or the seat to be outside of the jurisdiction, you can elevate yourself to be an international commercial arbitration subject to a different set of rules and different appeal rights. So for an international arbitration agreement to be binding, and again, very little is required, surprisingly, under the New York Convention, the agreement must be in writing, and that is, it must be in a document signed by the parties or in an exchange of written communications. It deals with future or existing disputes, and the disputes are in effect of a defined relationship, usually a contractual relationship, and they concern a subject matter that is capable of arbitration or settlement by arbitration in the jurisdiction in which the arbitration is being held. Most disputes are. There's some disputes, usually public policy type disputes, that are not capable of being the subject of arbitration. For example, there's been a move with consumer protection type arbitrations, and that for consumer protection reasons and to protect the public, that those not be held in private arbitrations. So again, those are the international requirements. Just to give you sense, these provisions have been held to be valid and enforceable. Any dispute is to be settled by arbitration in London. Resolution of disputes, arbitration Paris. Both of those constituted a valid and enforceable binding arbitration agreement, and they were in writing. I would just note that in domestic arbitrations, at least in Alberta, and I think across most of the Canadian provinces, the arbitration agreement, in fact, doesn't even have to be in writing. It can be held to be enforceable, even if it's not in writing. That there's a distinction there with the international arbitrations. So in distilling, those provisions, London, all disputes to be arbitration, London. In order to have an enforceable arbitration provision, you need only really be clear on the subject matter of the dispute. So disputes, or, if it's in a contract, the contractual disputes, the who is arbitrating. Well, in a contract, it's the contracting parties. So you don't even really need to distill those. And where is key. Where the parties don't provide otherwise, the place of the arbitration is considered the arbitral seat, and the arbitral seat will determine the law that applies to the arbitration itself. So the agreement, so those are the three basics, right? Be clear on what you're arbitrating, who's arbitrating, and where you're going to arbitrate. The arbitral seat will fill in any of the other gaps that are missing in your agreement. Now, some other things to consider just from an enforceability and valid arbitration provision side of things. Your agreement to arbitrate should not be optional. The language should be mandatory. So it's important that you use the mandatory language shall. I've just come across a construction agreement where arbitration was optional. The parties shall consider, and frankly was ultimately meaningless. It just automatically went to litigation. The other thing to consider, the importance of that provision. It's exigible. It stands on its own. If that contract that it is contained in fails or is held to be invalid for any other reason, it can be, and courts will extract that arbitration provision from the agreement. So it is very important. And it is like any other contract. It's considered its own separate agreement. And so, there must be capacity of the contracting parties to enter into the clause. It's subject to all those other capacity type issues that come up in any other contract, that one party may have been under duress in entering into the clause, that kind of thing. That often comes up actually in the consumer protection type legislation, where manufacturers and others have a clause, and the consumers have no ability to provide any feedback into that clause. So things like that. So that is the basics. Just decide what you're arbitrating, who's doing it, and where. But we don't recommend stopping, of course, at just dealing with those three things.
Karen, just to maybe pause there for a moment and just to ask a couple of questions. And
Sure.
So, firstly, you're speaking mostly about arbitration agreements within a broader agreement or transaction documents.
That's right.
But disputes can arise in circumstances where you don't have an arbitration clause in an agreement. And in those circumstances, can the parties then agree to arbitrate and have a standalone arbitration agreement nonetheless?
Yes, they can. It's always difficult to negotiate those with an unwilling party, particularly one who wants to delay the process through the court and unlimited appeals and that kind of thing. It's why I think generally in larger commercial disputes, especially those involving international parties, that the submission to the arbitration is when people aren't thinking about disputes. And to make it mandatory at a time when people are not playing chess in the midst of a messy divorce and where there are disputes.
People always tend to be a bit more reasonable at the outset when they don't know who's going to be on the receiving end of the dispute. So it does make drafting an arbitration agreement easier. Just while we're on that point, just to mention, obviously we're talking about commercial arbitrations, and there are obviously a whole other set of disputes that may arise in the investor state context, and those being subject to potentially bilateral investment treaties or other trade agreements, and arbitration can arise in that context as well. So that is another thing to consider, obviously, at the outset when you're entering into a transaction or agreement, is whether the state in which you are doing business or making an investment has a bilateral investment treaty or trade agreement that you might be able to take advantage of. Just before we move on, Karen, and talk about some of the other factors to consider, I'm just wondering whether, Rahat, maybe you can tell us a little bit about having a Canadian seat. So Karen has talked a bit about the importance of designating the seat of arbitration, because that's going to be the law that applies to the arbitration. What can you tell us about designating Canada or a province within Canada as the seat of arbitration?
Yeah, thanks, Tracey. That's a good question. As Karen mentioned, that's a really important decision, because that is going to determine the law that's going to apply to your arbitration. It's going to determine the courts that will be involved, the extent you need court involvement within an arbitration, for example, because parties can't agree on an arbitrator or enforcement or setting aside, like those kind of things. It's going to impact what your seat is. So it's certainly an important decision, and sometimes, as Karen also mentioned, these are midnight clauses, and parties will just take sometimes maybe a seat that was agreed in another contract at a different time without giving some thought to this. And I think it's important to think about. Canada is an excellent choice, in my opinion. Picking the major cities within Canada as your seat of arbitration is definitely a great choice for a number of reasons. I think some of the top reasons that come to my mind are things like Canada is a bilingual country with a rich tradition in both common law and civil law. So to the extent you're dealing with parties from different jurisdictions that have different legal regimes, Canada is an excellent place where you can find arbitrators and lawyers who would be familiar with and comfortable with both of the legal traditions. That's one thing to think about. Canada also has an excellent reputation for being a neutral and fair country. It's an arbitration-friendly jurisdiction, and what I mean by that is courts are supportive of arbitration. Courts are supportive of party autonomy. Canada is a model law country. It's a signatory to the New York Convention. So those are, again, great advantages when we're talking about best practices in the context of international arbitration and enforcing awards. All of those things are good factors to think about. Another thing I would mention is Canada also has really good arbitrators. So some of the world's leading arbitrators come from Canada. There's a lot of expertise in terms of counsel as well. And lastly, but this can be an important thing as well, is cost to think about. So some of the things I mentioned as advantages, you may be able to avail yourself of the same benefits in some of the traditional seats of arbitration, like New York or London or Paris. But cost is something that I think within Canada, it would certainly be, you'd be getting the benefits that you might get in some of the other seats, but at a significantly lower cost. So that's something else to keep in mind.
Thank you, Rahat. I don't know if any of the other panelists wanted to jump in on that question before I turn it back to Karen. Hearing no one. Karen, I don't know if you want to tell us a little bit more about what you're arbitrating, and issues that can arise in that context that lead to questionable enforceability?
Yeah, sure, no problem. And I agree with you, Rahat. Canada is Calgary. Canada is a great place to arbitrate, mostly, in my opinion, because the courts generally do not intervene in arbitration and are very deferential to valid and binding arbitration clauses. So now, what to arbitrate? I would say that in most cases, with some exception, maybe in the construction context, parties agree to submit all of the disputes that arise out of or in connection with, including with respect to the validity of the agreement, to binding full and binding arbitration. And, I think that is, frankly, the best way for parties to arbitrate. Often in construction contracts, what I've seen is that parties during the course of construction, and because they do not want disputes to delay the project, they will nominate certain kinds of disputes under the contract to be arbitrated. So, for example, change order disputes. Change order disputes, I have been involved in a recent arbitration where there was a bifurcated process where only change order disputes were to be arbitrated and all other disputes were to be litigated. Now, that, of course, led to huge delay and multiple proceedings and an argument as to what a change order dispute was versus all of the other disputes. There was an argument that the change order process itself had been abandoned, that the fixed lump sum nature of the contract had been abandoned, and ultimately, in that case, what happened was all of these multiple proceedings, and with a number of court delays, the parties entered into a submission agreement. So they redrafted their entire arbitration provision that had been contained in their EPC contract and spent 6 months going back and forth on a submission agreement that would have all the disputes decided by arbitration. So ultimately that resulted in all kinds of delay and expense for the parties that was unnecessary. I think in my experience, unless there's a very, very clear reason, avoid bifurcating your disputes. Do not litigate some and arbitrate others. Either litigate them all, and that's still open to you. Probably less appeal for those who are international parties and from different states, but avoid bifurcation would be my general feeling.
And great advice, because I think one of the things that arises quite often is dispute about the difference between tortious disputes or non-contractual disputes and whether those are also subject to the arbitration or not. And careful drafting of the arbitration clause, if you want everything to be included, is important. The other issue that arises in terms of bifurcation is when you have multiple parties and involved in a venture, and they're not all parties to the same arbitration agreement. And issues can obviously arise in that context with respect to multiple proceedings or multiple arbitrations where the parties haven't agreed to a consolidated process. Anyone want to address the problems that can arise in that context and how to avoid them?
In the multi-party?
Yes.
Yeah, I'm happy to field it first, and others can join in. So that often arises in construction cases, of course, too, because you have the dispute proper between the owner or employer, if you're British, and the contractor, the main contractor. And then, of course, the contractor is going to want to point fingers at all the subs and design deficiencies in manufacturers and that kind of thing. The key to arbitration is, of course, a party submission, a consent. It's how the tribunal takes jurisdiction over the parties. And so if you are going to want to bring in multi-parties, it has to be the case that all of the other subcontractors involved in the construction of the project have a submission agreement and an identical arbitration provision, and where they expressly agree to a consolidation of all the arbitrations. So do that ahead of time, because there's no way to compel a third party, even with the court assistance, if there's been no submission at any point. Geoff?
And if I could add to that, yeah, it's something that, and I'll describe as we go on a little bit more about how a litigation funder works. But the short version of it is that we have an interest in the proceeds of the litigation, and so we're pretty laser focused on making sure that there is an enforceable monetary resolution at the end of the day. And so one of the big potentials for mischief or misfortune along the way of an arbitration is proceeding against a party that isn't, as Karen mentions, properly bound by the arbitration agreement. And so we have a very careful look at matters of corporate structure. So in the instance of a commercial arbitration, are you suing the right corporate party, or are you actually suing an entity within the umbrella of that organization that is legally distinct but has committed the wrong? This is going to lead you to a couple of bad places very quickly. One is if you do get the wrong party, you're going to face a jurisdiction motion within the arbitration when that party picks it up, which is just added time and expense. And the other is if you do proceed and get an award, but there is some question or colorable argument that one of the parties the party that you have an award against wasn't properly before the arbitration, that's going to be raised on a set aside or enforcement as a grounds to invalidate the arbitration award. And if that is successful, then you're back to square one, all of which is to be avoided. So yeah, that's something that at the contract drafting stage, if you can, is great to pay attention to. And certainly when you're commencing the arbitration, very carefully considering who it's going against and are they properly bound.
Thank you, Geoff. So Karen, other considerations with respect to drafting that you want to touch on briefly?
Yes, I see that we're running out of time. I'll maybe pick a few considerations as far as the who of the arbitration. We've talked about multiple parties. The other who of arbitration, of course, is who's going to decide it, how many arbitrators, and what do you specify as far as their qualifications. I think in domestic arbitrations, and certainly the default under most provinces' domestic arbitration legislation is that it is a sole arbitrator. You're more interested in a panel of three in international arbitration, and typically the selection process there and the default legislative process in Canada is that each party picks their own arbitrator and those parties pick the chair. That is some considerations as far as the who of arbitration. We've talked about the where and the importance of the arbitral seat. Thanks for that, Rahat. And just keep in mind, again, the top tip there is remember where the arbitration is located. The place of the arbitration is generally the default of its arbitral seat. That's the law that will govern the proceedings. And so you're going to want to make sure that place or the arbitral seat is a signatory to the New York Convention, and that there's limited court intervention in arbitrations generally.
The one thing I would add to that is obviously when you are drafting the arbitration agreement and choosing the seat, you also want to think about where, if you're the party who's going to be potentially advancing an arbitration, where am I potentially going to have to enforce the award? And we'll talk more about that at the end, but that's also important when you're drafting to bear that in mind in choosing the seat. And also in terms of choosing the seat, I'm thinking about what potentially issues might arise where the law of the seat will be applicable. And it's really more problematic where you have ad hoc arbitrations as opposed to administered arbitrations where you have a set of rules where you're governed by that. Think about all of the potential issues that might arise and set out a process which will govern. In ad hoc arbitration, there's much more risk that the law of the seat will actually end up applying, and you, particularly in things like costs, you might not think about. Different jurisdictions have different rules with respect to costs and whether or not it's going to be a prevailing party rule or parties bear their own costs, and that can be a significant fund or amount at the end of the arbitration that you're going to have to pay because you haven't thought about what are the rules that are going to apply. So those are all things that we can only scratch the surface on today, but are obviously important issues to think about. Just going back, though, to your point about the who of arbitration in terms of the arbitrator and how important that is. One of the benefits of arbitration, obviously, is that you can, to a certain extent, select the adjudicator, the person who is going to be making the decision. And part of the benefit of that is that you can choose people who have expertise in the area. And particularly in mining disputes, that can be really important because you want somebody who has familiarity with the area and knows what you're talking about, understands the language that you're speaking. And so what I have seen often in arbitration clauses is people specifying names of particular individuals who would serve as the arbitrator. And that, in my experience, has led to nothing but trouble because when those people are not available, you then are left with a clause that is potentially unenforceable. Any thoughts, any of the panelists, on how to get around that and what to do in those circumstances?
I'm happy to just weigh in here, Tracey. I've seen that too. I've seen people identify particularly industry leaders as a sole arbitrator. And as you indicate, that can lead to a frustration of the arbitration agreement if that arbitrator is no longer available or not available in the time frame even. Instead, I think you should consider some loose qualifications, law degrees or industry experience and a minimum level of experience in the industry, 10 years. I wouldn't make them too onerous. And if you must indicate a sole arbitrator by name, make sure there's a parachute clause that allows, if that person is unavailable or worse, that allows the parties to agree on a different arbitrator or the court to intervene, would be my suggestion.
So great suggestions. And one thing we haven't spent too much time focusing on yet is the difference between an ad hoc arbitration and an administered one. And Geoff, maybe you can tell us a little bit about what is the difference between the two and what are some options for administered arbitrations and why different institutions might be considered. And obviously, I would put a plug in for using VANIAC, which is the Vancouver International Arbitration Center. And there are fantastic organizations in each of the provinces. But Geoff, let's hear from you on some of the general comments.
Sure. Thanks, Tracey. There are a number of institutions globally that administer arbitrations. And what that means is they act as a sort of overarching administrative body that does things like collect deposits, has their own system of rules, and may or may not appoint arbitrators to hear the dispute. And so that is an authority that you can specify in your arbitration clause. And what you would do, that they would have a procedure by which you would start an arbitration under that institution, and someone from that institution, the administrative part of it, would then administer the arbitration for you, would act as sort of clerks and an administering body that takes care of all the logistics. Not all arbitration some examples of that would be the International Chamber of Commerce, so the ICC. If you're dealing with bilateral investment treaties or disputes under bilateral investment treaties, ICSID is the main administering body. But not all arbitration clauses will specify an administering body by way or on purpose or otherwise, and that's referred to then as ad hoc arbitration. And so what will occur then is essentially the contract or the arbitration clause will set out a method for the parties to agree on an arbitrator or an arbitral panel, and that arbitrator or panel will then administer the arbitration, him or her or themselves, under a set of rules agreed to by the parties in advance or under a procedure that the arbitrator sets. There are pros and cons to both of these things. An ad hoc arbitration can be faster, can be cheaper, but in the case of a recalcitrant defendant or respondent, it can be advantageous to have an institution push things along as well. So it really is, it depends on the case and the needs of the case. There was a question that came up in the chat about institutions that are suitable or recommended for cases in the mining sector in Latin America specifically. I think Latin American country will have its own local sort of chamber of commerce that administers arbitrations. The ones that would come to mind that we would recommend anyways from our perspective that we have experience with is for investor state disputes. If the respondent state has ratified the ICSID convention, then ICSID will be the governing institution, and that is sort of the norm for bilateral investment treaty disputes, and certainly a very obviously reputable and normal institution to administer these arbitrations. The ICC, while not a specifically Latin American body, does have Latin American offices and employees. And so they are a normal choice as well for administered arbitrations, commercial disputes between mining parties. And a specific one, perhaps, that it comes recommended to us anyways, is the Canada-Brazil Chamber of Commerce for Brazilian disputes that's located in Sao Paulo, has a very good reputation as well. That's not meant to be an exhaustive list, and I don't mean to alienate anyone or any country on the basis of not having included them, but all of which is to say there are lots of institutions out there that are good for these things. It just depends on the parties involved and the type of dispute.
And sometimes having a neutral institution is preferable if you are working in a country like in a Latin American country where you don't necessarily want to be the outsider in the process. And so that's an important thing to think about too, as is language. If an arbitration is going to be conducted in a particular language, you want to make sure that you have sufficient skilled counsel and arbitrators that you can choose from who are capable of conversing in that language. So that's obviously a factor too. So all things that should be discussed with whoever is drafting the arbitration clause or arbitration agreement as it comes up. In terms of, and this is something that has been mentioned a couple of times, and that is if you have a recalcitrant party, how that can impact the process. And that is really still a difficulty with arbitration. And so one question that arose prior to today, a pre-question was, what disputes would you not want to be arbitrated? And I think there are a limited number of disputes which would not be capable of arbitration. Karen has mentioned some of those, including consumer protection type claims. But arbitration can be difficult where you have fraud, for example, or a party who has an interest in the dispute not getting resolved. And that is something that's much harder to predict in advance. But it still, in those circumstances, can be difficult, particularly if you have ad hoc arbitration and you have a party who doesn't want to reach agreement on anything, and where you have arbitration requiring people to pay in sums of money in order for the arbitration to continue. You can sometimes run into problems with one party not paying. And I think, Geoff, maybe we'll touch on that a little bit later. just talking about some of the things that can arise in the course of arbitration that lead to issues with respect to enforceability. And one of those is typically in an arbitration process, whether you have administered or ad hoc, the parties will at the outset have a specified procedure for dealing with document disclosure and exchange. And sometimes when you get into an arbitration, notwithstanding that the procedure is intended to make sure that all of the documents are exchanged in advance of the arbitration, that doesn't happen, and documents end up getting disclosed, or somebody attempts to put a document to a witness in cross-examination. Rahat, how would you recommend dealing with that and ensuring an enforceable process in that context?
Yeah, that's a good question. So I think there are two things to sort of keep in mind, and I'll talk a little bit more later on about the enforcement framework and the grounds on which enforcement can be refused. But for this question, I think there are one or two provisions, and when I say provisions, I'm talking about the New York Convention and the model law that could potentially be a basis to refuse enforcement that I think impacts this documentary issue. One is the party's ability to present its case. So where a party hasn't had a fair opportunity to present its case, that can be one of the grounds that can be raised at the enforcement stage. Another ground that can be raised is where the arbitral procedure is not in accordance with the agreement of the parties. So the answer to this question, I think there isn't one sort of specific answer, really. It turns on what the parties agreed to, what was the process, and whether that's being followed or not being followed. So presumption in an arbitration often is that you don't want an element of surprise at the hearing itself. It's unlike trial, where a lot of the strategy actually depends on taking another party by surprise. In the arbitration context, it's quite the opposite, where the presumption is that parties will know their case and will know the evidence in advance of the hearing and in advance of any sort of determination of the merits. And so what that means is either the parties will have agreed on a process, or if they haven't agreed on a process, then when they meet with the arbitration panel, for example, at the initial procedural meeting, they will sit down and discuss what the process is. And part of that, there will be discussion of deadlines, including production of documents and seeking documents from the other side and all of that. And more often than not, in my experience, there'll be a cutoff date where sort of any new documents or additional documents that a party wants to rely on at the hearing need to be produced. So if all of that is the case and parties have agreed on a process, and then at the 11th hour, and even worse, like at the hearing itself, you come up with a new document, I think it's possible that the arbitrator may not allow that document to be admitted or be put to a witness. And where sort of proper process was followed in advance and there was every opportunity for that party to present its case, I think it would be okay to deny admitting, and I don't think that would be grounds for refusing enforcement later on. I think the party would need to have a really good reason if you're coming up with a new document or new evidence at the hearing and couldn't disclose it in advance. There would have to be a really good reason, and I think you would need to seek leave and sort of show why it's important. If it really is important, or where there wasn't agreement on a process, I think there may be more leeway. But where deadlines have been agreed and everybody has signed off on that, I think it's harder to get around it unless there's a really good reason.
And I think the party who has the document in hand, if they want an enforceable process, really has to think twice about, do I really need to put the document into the record, or can I just use the document without putting it to the witness in cross-examination, so that I don't taint the process by having an arbitrator decide it's admitted into evidence, and then somebody has an argument later on. So I think you really have to think twice about that. One other issue that often arises in the arbitration context that can lead to an unenforceable arbitration is bias or a conflict of the arbitrator. And so I think that is something that important to touch on today, which is, what do you do in circumstances where, particularly where you have a three arbitrator panel and you have two party appointed arbitrators, and you have one particular party appointed arbitrator who is a bit too connected with the party who appointed them, or too aggressive in trying to advocate, act as counsel, an additional counsel for that party during the proceedings. Christian, I don't know whether you have had occasion to deal with that, or what your thoughts are on how best to deal with it if and when it arises in the course of an arbitration.
Always delicate, right, Tracey? Because you are appearing in front of the arbitrators. You don't know what will happen, if there will be accusation. But I think in the end, a lot of those questions bring us back to the importance that we should not forget of having administered arbitration. I mean, adhoc arbitration, yes, and Karen, said it. There's advantages and there's, but if you're within a framework where you are allowed to raise those bias issues with not only the panel, but also a super organization that can review it and appeal and give you some comfort, it's always better. And as counsel, it's difficult to pull the trigger on the bias question sometimes. But if you know that you can be within a framework that ultimately you can prevail and continue the arbitration, sometimes you have to. Sometimes, for example, comments of arbitrators are such that you can't just ignore them. But it's always a very delicate issue to raise.
And I think that goes back to the importance of choosing your arbitrators. And if you are in a process where you have the right to select one arbitrator and then the other two arbitrators select the chair, you hope that they're going to choose a chair who's going to be effective and to make sure that the process is a fair one and that questions are not being put to witnesses that are inappropriate or clearly designed to try and assist one of the parties, and maybe delicately raising it and trying to just make it obvious to the chair that you're starting to become concerned without directly raising an allegation of bias, because once it's raised, you can't put that back in the box, and it can make the process more challenging. The key is to make sure that the parties feel like they're getting a fair hearing, and that is generally speaking important to the arbitrators. And there's very few exceptions where you'll find an arbitrator who is not behaving appropriately, but depending on the jurisdiction that you're dealing with, it can happen on occasion and can be difficult to deal with.
And
sorry, go ahead, Christian.
No, I was just going to say, you raise a good point, Tracey, where there's an advantage there of having three arbitrators as compared to one, because they can talk to each other, they can control each other, and yes, if you have a president that's on that's really present and understands what's going on, it can be very useful, and that's certainly an advantage of having three arbitrators with respect to one.
I couldn't agree more. Christian, usually they're a bit of a spot check for each other on keeping some of their opinions to themselves. I would just add to that, whether it's administered or ad hoc, either during the course of the arbitration in Alberta under the Domestic Act or even after an award, it is one of the few bases for setting aside an award, where there has been where the parties have been manifestly treated unequally and unfairly. And so if you are going to make that argument, I would be planting even subtle seeds in the transcript as you go. Madam Chair, I noticed that when my friend made a similar evidentiary objection, something was decided differently. Or, Madam Chair, I note that you're shouting. It has to be apparent in the transcript. It's a very difficult question, or a very difficult argument to make, but it is that one of the limited circumstances where you can get court intervention. But it's proceed carefully. It's such a ginger dance.
And that is the case in most jurisdictions in Canada under the arbitration, either domestic or international rules. That is one of the few grounds on which you can have an arbitration award set aside. And so I think, you raise an important point, because not all arbitrations are video recorded. Some are only audio recorded. And some things that occur in the course of an arbitration may not be audible, they're visual. And so you need to make sure that becomes part of the transcript if it is an issue at the time.
Yeah, definitely.
So I think we should probably move on to talking a little bit more now about enforcement of foreign arbitral awards. And Rahat, if I can ask you to just touch on some of the issues that arise and how to make sure that you go about enforcing arbitral awards once you have one.
Sure. Thank you, Tracey. So everything we talked about so far that Karen largely touched on was, making sure your clause works, making sure we have a good process, you get an award. Now, at the end of the day, it is the right party. So, it does bind the parties. But an arbitral award in and of itself doesn't really contain a mechanism for enforcement, for example, through garnishment or, a seizure and sale process that might be available where you had a court judgment and a party did not comply with it. You can't do that automatically in the arbitration context just by getting the arbitral award. So where a party does not voluntarily comply with the arbitration award, it does become necessary to obtain a court judgment enforcing that award. And if a party is seeking to enforce an international arbitration award, it does need to bring an application to a court in the jurisdiction where it does want that award enforced. For the purpose of today's discussion, I'm going to focus my comments on two instruments that are significant for enforcement of foreign arbitral awards in Canada as well as internationally. And those two instruments we have already made reference to a little bit earlier on. They're the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards and the UNCITRAL Model Law for International Commercial Arbitration. The New York Convention that some of you may be familiar with, it's similar to a treaty that has been adopted, ratified by a number of states, whereas the model law is not really a treaty or an agreement. It's just a codification of international best practices for commercial arbitration that has then been used as a model by countries when they are developing their own arbitration legislation and laws. The convention currently has 169 states as parties. And so the advantage really of the New York Convention is that it does provide a uniform set of rules that facilitate enforcement internationally for arbitration awards. The New York Convention basically requires courts in contracting states to recognize and enforce awards that are made in other contracting states subject to very limited conditions and grounds for refusal. Canada is one of the countries that has ratified the convention, and the provinces in Canada have either specifically adopted the convention or incorporated its provisions within their international arbitration legislation. And so what that means is if a party obtains an arbitration award in one of the other contracting states, one of the states that is a party to the New York Convention, and then seeks to enforce that award within Canada, it is the provisions of the New York Convention that will apply. And similarly, if a party obtains an award in Canada and wants to enforce it in one of the other 168 states, then again, the same provisions for enforcement will apply. The model law, as I mentioned, is not really a treaty, but it's an example of international best practices. And most of the international commercial arbitrations legislation within Canada has incorporated the model law either in whole or in part. So certain provinces, for example, Ontario, our International Commercial Arbitration Act specifically says that both New York Convention and the model law have force of law in Ontario. There are other provinces that don't have that specific language, but they've taken provisions from the model law and incorporated those within their legislation. And if a party brings an application to enforce an award pursuant to the model law, again, the court has to enforce it. And in this case, it doesn't matter what country the award was made in. The enforcing court must enforce it unless that you can show that you fit within one of the narrow grounds for refusal. So what are these grounds for refusal? That's really the important framework when we're talking about enforcement. There are some narrow grounds that are set out in model law, and these are virtually identical to the grounds that are set out in the New York Convention. And they're also pretty close, almost identical also to the grounds for setting aside an award at the seat of arbitration. So these grounds, which are set out in Article 36 of the model law and Article 5 of the New York Convention, basically say that enforcement of an award may be refused only if it established, one, that a party to the arbitration agreement was under incapacity, or the arbitration agreement was invalid, or the party against whom the award is sought to be enforced was not given proper notice of the appointment of the arbitrator, or of the arbitration proceedings, or was otherwise unable to present its case. This is the provision that I mentioned before. Another ground is the award deals with the dispute that was not contemplated by the arbitration agreement, or contains decision on a matter that is beyond the scope of the arbitration agreement. Another ground is that the composition of the tribunal or the arbitration procedure was not in accordance with the agreement of the parties or the laws of the country where the arbitration took place. Another ground is that the award has not yet become binding on the parties or has been set aside or suspended by a court of the country in which or under the law of which the award was made. Or the subject matter of the dispute is not capable of settlement by arbitration under the laws of the enforcing jurisdiction, or enforcement of the award would be contrary to the public policy of the enforcing jurisdiction. So those are the grounds that are set out in both the New York Convention and the model law. And there are a couple of things about these grounds that I do want to highlight because I think these are important takeaways. One, the list of grounds that I just mentioned, it's a narrow list and it's an exhaustive list. And so you do have to fit within one of these grounds if you're trying to challenge enforcement of an award. A party that's trying to refuse enforcement cannot raise a new ground or some other ground that's not set out in the convention or the model law in its attempt to resist enforcement. Also, the burden is on the party that is trying to resist enforcement to show that one of these grounds applies. It's not on the party that is seeking enforcement, and that's important. And lastly, I think what's really important to remember is that the enforcing court has discretion to enforce the award even where one of the parties has shown has presented evidence and has shown that they fit within one of these grounds. So both the model law and the New York Convention use permissive language. Essentially, they basically say enforcement may be refused if one of these grounds are established. It's not a mandatory requirement. So even if someone proves that the arbitration agreement was invalid, or they didn't have an opportunity to present their case, or an award has been set aside in another jurisdiction, it doesn't mean that the enforcing court has to refuse enforcement. They do have that discretion. So that's sort of the basic framework of enforcement of awards in Canada and under the New York Convention internationally.
Thank you, Rahat. Anything with respect to time limits that parties should be mindful of?
So the convention or the model law don't really stipulate a limitation period for enforcement of international awards. The New York Convention does say that it's going to be the local rules and procedures that apply. The New York Convention also says that the procedures cannot be substantially more onerous than what would be the case, or can't have higher fees than what would be the case for domestic arbitration awards. So there's some guidelines there, but not a specific time limit. So really, it does turn on what the provincial limitation laws are. And in Ontario, that is 10 years. So the limitation period under the Ontario International Arbitration Act, you've got 10 years if you need to do this.
And if I could just make one point on the, notwithstanding the issue of setting aside for invalidity, there's all kinds of law, including legislation, that if there is an invalidity in respect of the arbitration agreement, you can't waive it. You can't participate it. In fact, in Alberta's Domestic Arbitration Act, you're not allowed to participate in the arbitration if you have a validity argument. So just, some of those regular grounds, it's the interplay of sort of arbitral seat and all that kind of thing. If there's an invalidity issue, I think there's a risk to sit on it until you get your award.
And obviously, the seat of arbitration, depending on what limitation issues arise in that jurisdiction, you have to be mindful of those in addition to the jurisdiction in which you're intending or attempting to enforce the award in. So I think we should probably move on to talking a little bit about OHADA, Christian, and that is a regime that you are particularly familiar with and have expertise in. And if you can just tell us a little bit about OHADA and why it's important in the mining space, particularly if you're engaged in mining in Africa.
Sure, Tracey. So just a few words on OHADA, and I apologize in advance if most of you know what it is. But OHADA is a French acronym that loosely translated means Organization for Business Law in Africa. And there's 16 states, it's treaty, 16 African states signed it. And under the OHADA space, you have certain uniform act that are called Uniform Act on different topics of laws, one of which is on arbitration. And it governs arbitration when the seat of arbitration is in one of those 16 states that are member of the OHADA space. And there's a few advantages that you should know to avail yourself of the Uniform Act on arbitration. And more particularly, I'll come to that, the Common Court of Justice and Arbitration, the CCJA, that is, simplicity said, the equivalent of the ICC within the OHADA space for administered arbitration. So just a quick overview of the arbitration under the OHADA space, and then I'll move quickly to enforcement, because as we'll see, if your arbitration is under the umbrella of the CCJA, there are a few very good advantages with respect to enforcement when it comes to that later on. But a few words to say that, again, you do have the choice between an ad hoc arbitration or an administered arbitration in the OHADA space. If you choose an ad hoc arbitration, you're going to be under the umbrella of the laws of the state where the seat of the arbitration is, which means that at the end, if you want to exemplify your decision, you'll have to go in front of and make a motion in front of the state tribunal to get it enforced. Enforceability will only be good for that state. And if you want to enforce it against assets in other states, you'll have to do, as we know it, proceedings in every of those states. Moving quickly to, if you decide to have an arbitration under the CCJA, well, then the enforcement of a decision rendered under the CCJA rule rules, I should say, is much easier. First of all, very big advantage. It's enforceable in all the 16 states that are members of OADA. You don't have to go state by state to get enforceability and execution order, which is a big deal. The second thing is that the motion to enforce or to exemplify your sentence, your decision, is much simpler. You basically go to the president of the CCGA, and he or she or a delegate of the president will simply render the execution and the exemplification of the decision. And from that point, you're good in 16 states. So we were discussing earlier on the advantages of having administered arbitration. In the OADA space, it is definitely a big advantage to go CCGA. How do you go about that? Well, again, all the principles we've seen so far, you have to have a convention or a clause that specify that you want to be under the CCGA. The convention or the clause, as it is in many jurisdictions, is distinct from the arbitration itself, so the validity can be looked at in a distinct way. But the Uniform Act on Arbitration in the OADA space allow you to choose basically your rule of proceedings. So that's where you would put the CCGA, and also the laws applicable to the arbitration. So again, just a few words though on the arbitration convention or agreement or clause. There's a bit of a paradigm here because OADA will tell you that you don't have to have a written agreement for the parties to submit or to demonstrate that they had agreed to arbitration. But when it comes to execution, if you're within an adhoc space, you'll have to prove a written agreement between the parties. So basically, you don't go with any other thing than a written agreement on arbitration, and that's valid with respect to ad hoc arbitration and administered arbitration under CCGA. So if there's a few takeaways here, it's you have to have a written agreement. And you also, I believe, if you have your eye on enforceability, which we all do, you better be under the CCGA because it makes things much simpler. And as Geoff will tell you, I'm not sure that Omni Bridgeway I mean, I'm sure they do, but they would look at whether or not CCGA is involved or not when funding arbitration in the OADA space, because there is a huge impact on enforceability. So that being said, what I want to say is that it's a system that works well. It's a system that allows you to be on the ground where you are and access enforceability quicker and easier than not. And I mean, if you're within CCGA rules, and you can be successful in getting an award and having it enforced within the OADA space. Last comment I'll make is that there is a huge push for African countries that are part of the OADA to demonstrate to the world that it is a safe and an organized space to do business and resolve litigation through the OADA CCGA mechanism. And so, although it's not perfect, and sometimes national authorities in certain aspects can intervene, and I mean tribunal of states within the OADA space can intervene in the arbitration. If you're under the CCGA, more or less your appeal and your safety net is at the CCGA. which is a more neutral and organized sometimes space to deal with the issues of arbitration.
One question, Christian, which is, if you're operating in the OHADA CCGA space, can you use Canadian counsel or arbitrators from outside of whatever country it is that you're engaged in? And what is the benefit or disadvantage of doing that?
So you can definitely use arbitrators that are outside of the space. The Uniform Act on Arbitration will tell you that you have total control on choosing your arbitrators. If you don't have any means of choosing your arbitrators, well, then if it's under the CCGA, the CCGA will appoint arbitrators, and there's a list of arbitrators at the CCGA. But the parties control that. And again, it goes a long way towards what Karen was saying, which is the more your agreement is or foresee and sets down the rules of how you choose your arbitrator, the better it is. As far as counsel, absolutely, you can have counsels from jurisdictions that are outside of the members of the OHADA space, and sometimes the advantage of doing that. And then I'm from Canada, of course, but to have a Canadian counsel is that I can't stress enough, and you've alluded to it, the fact that we are seen as neutral, and are historically Canada has always been more of a neutral country. Historically, our footprint in Africa has always been positive, and all of that, I think, is our advantages towards Canadian councils to get involved into arbitrations within the OHADA space, and we're always welcome. I've never encountered anything but being welcome in the OHADA space.
And I think that's particularly important in terms of being receptive to the arbitrators who might be individuals from those countries, where you want to make sure that you're not appointing counsel who's going to rub them in the wrong way and get off to the wrong start. Geoff, did you want to add with respect to the issue of costs? From your perspective, Omni Bridgeway perspective, is that something that you look at in considering arbitrations in the jurisdiction in terms of whether or not they're ad hoc or administered?
Yeah, I mean, costs is something we focus on quite a bit, and as I'll set out in a minute, the business model that we have is to pay the costs of the arbitration to some extent. So we are, of course, keenly aware and monitoring what is being spent. Administered arbitrations can be more expensive because there are institutional fees that, in addition to tribunal fees, in addition to legal fees, that you have to pay. But as Christian alluded to or mentioned, that there are sometimes some real value from an institutional perspective to having that institution aid in the execution of the awards. So in most cases, I would say that those costs are more than worth it. It just will depend on the overall metrics of the investment, whether whether it can be borne or not. Another area where we look at costs is the cost of lawyers, and I would also then give a plug for Canadian lawyers in that respect, because in international arbitrations, it's not certainly a cheap enterprise, no matter how you do it. But having a specialized bar in Canada and firms like Fasken that are very, very good at it, but they might actually be quite a bit more cost effective than your international firms that do this kind of work, is also a huge advantage from a funder's perspective. So I would echo the plug for Canadian seat, Canadian counsel, and Canadian counsel on very international things, including under foreign law, under the OHADA arbitrations as well.
Well, thank you for that. And if I can ask you now to talk a little bit about what Omni does and how you decide what cases you take on and monitor them as the proceedings continue.
Sure. Thanks, Tracey. Yeah, and I'm sort of, I guess, moving a little bit backwards here because I've been making comments on this throughout, and maybe you're not aware of what a third-party funder does or how it works. I wanted to discuss enforceability from the perspective of a party with a purely commercial interest in the arbitration. And so what Omni Bridgeway is we're a publicly traded company that provides capital for commercial disputes. And so our typical model is to pay legal fees and the other costs of advancing an arbitration in exchange for some portion of the proceeds of the litigation. So, and this is typically non-recourse, which means if the case fails, we don't recover anything and we lose our expended capital to boot. So we have to be very sure of a case on the merits before we fund it. And we also have to be sure that even if we win on the merits, that the matter is going to be, or the award is going to be enforceable, and we can get a monetary sum out of it at the end of the day. And so we do a lot of advanced due diligence on both of these questions before we enter into an investment. So in that scenario that I've just described, we're still a true third party to the affair. We don't control the litigation. The client continues to instruct the lawyer. We just pay the bills, but we are involved as a sounding board and a strategic resource to the claimant and the lawyers to the extent that that's valuable. We're all former litigators and/or arbitration counsel, so we like to think that we have seen our way around these proceedings and know what to look for. There are other models that are a little bit outside this, which involve taking assignment of claims and acting as the litigant itself and purchasing the claim. Those are a little bit more unusual, typically more when there is already a final judgment or award. That's more appropriate. So the usual scenario is that we are funding the client who remains the client, and we act as essentially a source of project funding for that arbitration. We're quite active in mining and natural resources because they lend themselves pretty well to this model. Our industry really did grow up around providing capital for David and Goliath type disputes, as in when a company's revenue generating asset is expropriated or otherwise jeopardized by the act of a defendant. And so in those cases, the company often lacks the capital to pursue an otherwise valuable claim. Investment treaty cases often fit that mold where a sovereign has expropriated a mining project. I think the most recent ICSID stats, and ICSID again is the administrative body that administers most of the investment treaty arbitrations. Their most recent stats are something like 25% of their cases are oil and gas or mining cases. So infrastructure and energy are a huge area for them and represent like a good portion of the claims that they see. And in addition to those type of claims where clients simply can't pay for it, we're seeing anyways, it's being increasingly used by well-capitalized clients, including large cap mining companies for both investment treaty cases and commercial cases like downstream disputes, royalty disputes that they have with their commercial partners. Just a couple of illustrative examples. We have an ongoing investment for TSXV traded Vancouver-based exploration company against an African government for expropriating a rare earth mine. And in that case, we're funding the arbitration proceedings in ICSID. That's all public. And we're also funding some commercial litigation for, again, well-capitalized mining companies. Again, these tend to be arbitrated disputes that are about pricing or royalties. As a result, they tend to be confidential. But so we are active in both ends of the spectrum in terms of the investment treaty and the commercial arbitrations that mining companies might see. Because our return comes only from the litigation proceeds, it's critical that we are sure that there's a monetary resolution and that we can actually get that money at the end. There is a piece of wisdom that floats around the litigation world that 98% of cases settle. I can tell you in arbitration that is not true. At least some of the statistics from the administering bodies bear that out. I think the ICSID stats from this year suggest that 65% of their cases go ahead to a full hearing and award. And from our perspective, we deal with a lot of high value disputes with sophisticated counterparties, including sovereigns on the other end. And our assumption when we enter an investment is that we are going to go the distance, meaning we are going to go to a full hearing, have to get an award from an institution, and we are probably going to have to survive some form of set aside or annulment proceedings. And then we are going to have to invest in some enforcement proceedings to compel the respondent to pay. So we are looking at it from a very global, long-term perspective, and we need to be sure that at the end of the day, there are assets that we will be able to seize or attach that will compel a payment of money to the client that we will then get a share of. And so sorry, Karen, go ahead.
Yeah, no, I was just going to have another plug for Canadian arbitration. If you settle an award in international arbitration, during the course of the arbitration, there are provisions in Canadian legislation that settlement be issued as an award. So it helps from a settlement, encourages settlement, but it gives people a lot of comfort knowing that the settlement can be enforced through an award, which then can be, enforced through the New York Convention and things. So just as an aside.
Absolutely. And that's one of the things, and I'll get into just a very quick list of the kind of factors that we would look for in a case to make sure that we're confident in its enforceability. I mentioned we have to be confident in the merits. That's kind of table stakes. We want to see obviously strong merits that will succeed, but we also want to make sure that there's no potential for either valid challenges that could make an award unenforceable, or for mischief, or to limit the scope of mischief type challenges that don't have a lot of merit in the challenge, but are designed just to delay things and frustrate the efforts of the claimant. The key one, I think, is jurisdictional. We want to make sure that, of course, and as Karen discussed with the parties to the arbitration, that the dispute that's being sent to the arbitrators is one that's capable of being arbitrated under the agreement or under the treaty. And so therefore that things are narrowly construed. If it's a contractual claim, that we're submitting a contractual claim and not including extraneous extra contractual claims unless they're absolutely necessary that might be subject to a jurisdictional challenge later. Do we have the right party to the arbitration? Are we sure about the corporate structure? The seat of the arbitration is, again, an interesting one that we've discussed a lot. That what we look for in a seat is really a well-reputed, neutral and impartial seat like Canada that has a reputation for good rule of law and has a good track record around enforcement of proceedings. If you make the assumption that we do, that we will have to enforce a proceeding in different countries and chase assets, your starting point is that you're going to have to recognize that arbitration award in the seat of the arbitration as a first step and then go international with it. And so having a reliable seat of arbitration with a good track record and good predictable laws around arbitration is vitally important for that. Something that should be paid more attention to in the drafting as opposed to at midnight. And certainly from an institutional perspective, and this is skipping over now to administration, but what Christian mentioned about the CCJA, very huge advantage in terms of getting an award recognized and enforced. Another thing that came up is
I should also sorry, Geoff, tell everybody that BITs or multilateral investment treaties can be submitted to the CCJA in the OADA space. They've opened it up a few years back, so that's also a possibility within the OADA space. Sorry, Geoff.
Not at all. That's a very good point. We also, the topic of bias came up and arbitrator partiality. We also look for a tribunal to be appointed that has a good track record, that's well reputed. You want a president or chairperson of the tribunal that you have confidence in, that can control the proceedings and won't allow those kind of problematic factors like bias or the appearance of unfairness to a party to creep in later. It's always hard to make those challenges, whether they be based on bias or just more garden variety procedural unfairness. But that doesn't mean that parties don't raise them later. And so making sure that you have a tribunal that insulates the proceedings and the transcript from that as much as possible is very important later. And then perhaps the last but most important thing is the question of assets. And so we always assume that we're going to need to take steps to enforce the award, not necessarily to obtain full satisfaction from those enforcement steps themselves, but to compel the respondent to come to the table and pay some of the amounts outstanding. So we do quite a bit of advanced asset tracing and monitoring work. We look for respondents that have attachable, valuable assets outside of their home jurisdiction, preferably, and in venues that are enforcement friendly and that have favorable attachment laws. So there are civil law jurisdictions, for instance, that will allow a claimant to take pre-filing attachment steps against assets that a respondent has. Those can be quite valuable pieces of leverage and a good way for a claimant to start an arbitration by seizing assets. It certainly changes the settlement complexion. And the typical assets that you might see attached would be things like aircraft, particularly those that are produced in other countries that are owned by national airlines. If you're dealing with a sovereign, ships that are containing the ships themselves or the goods they contain, shares in companies that the state owns, or various accounts that might be paid to regulatory authorities in different jurisdictions. And so we would do a pretty thorough workup in advance of what the asset position is, at least at the date of investment, and work up a strategy even before the case begins in terms of how that enforcement is going to play out. And so everything else that we've talked about, the seat, the jurisdiction, the arbitration procedure, the institution, all of that feeds into that core piece is obtaining an enforceable arbitration award, and being able to execute it in a jurisdiction that has assets.
Thank you, Geoff. Really appreciate it. And we're sort of running now out of time. A lot to talk about, and we really have just scratched the surface, but hopefully we've given people some food for thought. And we do have another question, which is arbitrators, should they always be lawyers or former judges? I don't know if any of the panelists have particular views on that. I think I wouldn't say always. Certainly if you have a sole arbitrator, it can make the process easier if you have somebody who has legal training to run the process and to make sure that they keep everybody focused and on track and pushing the procedure forward in a way that will be enforceable at the end. Having said that, certainly there are accountants, people who have engineering expertise, who do act as arbitrators, and for the particular disputes that can be very beneficial. So it's something worth having a conversation about, I would say. I don't know if anyone has anything contrary to say or anything else to add. Karen?
Yeah, I would just say I have a preference for lawyers over former judges. Judges tend to not be as acquainted with some of the more nuanced arbitration issues. And, the rules of evidence don't typically apply to the same extent in arbitrations. And so I prefer those arbitrators who've been more recently involved in particularly international arbitrations over a local judge.
I totally agree with Karen. I would venture to say that if, to the risk of appearing to protect my own profession, but if it's a sole arbitrator, you need somebody who can, deal with evidence and what happens in a courtroom, which is much more difficult than we can think. But if there's three arbitrators, sometimes there's real value of having a more technical, scientific person that can help the other two arbitrators in certain specific matters where it makes things much easier, and even the understanding of a cross-examination of an expert in a certain field is much more easier to conduct, for example. But hey, if you can have lawyers or judges, never say no.
And there are some unicorns out there that are both lawyers and engineers. which are great in the construction context.
You're right, and in the IP world too, Karen. There's scientifics that are also lawyers, and yeah.
Well, thank you all very much for joining us today, and really hope that we see you in person soon. And just perhaps to leave you with 3 tips from today's discussion, I would say, number 1, when you are drafting an agreement and thinking about including an arbitration clause, really do give it significant thought, because there are a whole bunch of questions that we've raised today that you should be asking whoever's drafting before you choose the particular arbitration clause that you sign off on. Number 2, once the arbitration is underway, think about enforceability and enforcement, and where you're going to have to ultimately enforce the award at the end of the day, because those are all things that you want to bear in mind. And number 3, if you are thinking about pursuing a claim and it's a claim worth pursuing, think about third-party funding. There are some recent decisions that on cost awards that make third-party funding even more attractive. So bear that in mind if you do have a dispute and you want to reach out to Omni Bridgeway or other third-party funders. It's a great option in those circumstances. So thank you all very much. The next seminar will be tomorrow on the future of nuclear power and environmental, economic, health, and safety considerations with respect to that. It is taking place at 8 a.m. I assume that is Eastern time, because it doesn't specify, but I believe that is the case. And you can sign up for any of the upcoming webinars at the Fasken Institute section of fasken.com. So again, thank you all for taking the time to join us today. We hope you found it of interest.